That one is the Employment and Miscellaneous Provisions Bill 2017, second stage, and I have great pleasure in welcoming the Minister. And well, now I have to put the question first that the bill be now read a second time. Is that agreed? Agreed. So, Minister, now I call on you to address the House.
Thank you, Cathaoirleach. I'm very pleased to have the opportunity to introduce the bill to this House this evening. The Government is delivering on its commitments, and the bill that's being brought forward is in response to the commitment in the programme for partnership government to tackle the problems caused by the increased casualisation of work and to strengthen the regulation of precarious work. If enacted, this bill will improve the security and the predictability of working conditions for employees on precarious contracts. I make no apologies for saying that there's a particular focus on low-paid, more vulnerable employees in this bill, and I know many members of this House share my interest in workers' rights and will have strong views on this legislation, and I genuinely look forward to hearing those views during the debate. However, I'm conscious of the vulnerable employees whose lives the bill will improve have been waiting almost a year since it was published, so I want the bill that emerges out of these House and the President being able to sign in law hopefully as quickly as possible, and please God before Christmas. But we also want to make sure that the legislation is balanced, resilient and that it works in practice. In a dynamic and ever-changing global environment, the Irish economy continues to strengthen and grow, thankfully, and the number of people on the live register is the lowest today since May 2008. The number of people in full-time employment accounts for 80% of all employment. However, we must remember that those people who, not by choice, are in less secure arrangements and may not know from week to week what hours they will be working. This makes it very difficult for people to plan their lives outside of work, and the bill that we're debating today will significantly improve the employment protections for these people. Ireland should be proud of its robust suite of employment rights, which provide broad protections to all employees. We have modern dispute resolution structures in the Workplace Relations Commission and the Labour Court, which are easy to access for both employers and employees. The WRC provides comprehensive early resolution, mediation and adjudication services in relation to the full spectrum of employment right cases, and all of these services are free to the users. It also has a proactive Labour Inspectorate which carries out workplace inspections to ensure the employment rights of workers and responsibilities of employers are respected. The WRC has an enforcement function in relation to breaches of employment legislation, and we have the second highest national minimum wage in the European Union. This bill is intended to build on that strong foundation. I took over responsibility for this bill in September 2017 when certain employment affairs functions were transferred from the former Department of Jobs, Enterprise and Innovation to what is now known as the Department of Employment Affairs and Social Protection. And I think, Chairman, it would be remiss of me not to acknowledge the work of those who came before me in this bill's journey. In respect of that, I want to acknowledge the work of Ministers Pat Breen and Mary Mitchell O'Connor, and to indeed your own Senator Jed Nash, who, as Minister for Business and Employment in the previous government, commissioned the University of Limerick to conduct a study on the prevalence of zero-hour contracts and low-hour contracts in the Irish economy, and I want to thank them for it. The bill is over 3 years in the making, and I think it's important for senators to understand the work that's gone into the bill, including the extensive consultations that have helped to shape and focus it. This work includes the University of Limerick study and the public consultation that followed it, and it also includes detailed discussions with ICTU and IBEC over a period of many months. And I'd like to take the opportunity to thank the many stakeholders who contributed to the development of this bill at the different stages of the process. We must remember that this bill will apply to all employers across every sector of the Irish economy, and I think it's important that we strike a fair balance between the respective rights and the obligations of employees and employers. The Government's approach in this bill is to try and ensure that where we are introducing new rights for employees or strengthening existing provisions in the law, the measures are proportionate and counterbalanced by reasonable defences for employers. We need to recognise the challenges faced by employers in running their businesses or providing their service. And we also must remember that the vast majority of employers are good employers who treat their employees well and who meet their responsibilities under employment law. These employers should have nothing to fear in this bill. On the contrary, the bill is aimed at tackling exploitive employment arrangements. So I want to make a couple of important points about this bill in response to some of the commentary as the bill passed through the Dáil, please. There has been much discussion in recent weeks on bogus self-employment. And I'd like to remind the House that if an individual believes that he or she is being denied employment rights appropriate to an employee, that they should pursue a case to the WRC. And similarly, if they believe that they may be falsely self-employed for PRSI purposes, that they should contact my department's scope section, and both services are free, easy to access to all users. The second point concerns the use of if and when contracts. There is a suggestion that the bill does nothing for employees on if and when contracts, and that's not quite true. I believe, on the contrary, the measures in the bill, both individually and in the round, will also help to protect employees on if and when contracts. The banded hours provision, for example, will apply to somebody on an if and when contract. So when they have worked an average number of hours over the previous 12 months reference period, they will be entitled to be placed on that band of hours that reflects the reality of the hours they've worked. Employers are also obliged to inform employees by the 5th day of their employment what the employer reasonably expects the normal length of the working day or the working week will be. There'll be no more waiting on a Sunday night for a text as to whether you'll be working for 1 hour or 30 hours the following week. Employers are also obliged to state the expected duration of the contract, where the contract is temporary or fixed term, on or before the 5th day of employment. Employees on if and when contracts will also benefit from the new minimum compensation provisions, where they are given notices of hours to work but do not receive those hours. And finally, employees on if and when contracts will also benefit from the various anti-penalisation measures. Thank you. When I completed my second stage speech in the Dáil, I said that I was proud to commend this bill to the House. However, the passage of the bill through the Dáil resulted in a number of opposition amendments being made to the bill. There was lots of compromise, I suppose, at the committee stage between amendments that came back and forward. And for example, we reduced the reference period in the banded hours provision from 18 months to 12 months on the suggestion of the opposition. We also accepted an amendment to reduce from 2 months to 4 weeks the time with which an employer must respond to an employee's request to be placed on a band of hours. But unfortunately, I was not able to persuade all deputies on a small number of problematic amendments to the department, and with the result is that the bill that was passed by the Dáil contains a number of provisions that I feel need to be revisited, and I intend to bring a small number of amendments at committee stage in the Seanad, please. I'll outline them as we come to the relevant section. So I propose now to outline the main provisions of the bill that were passed in the Dáil. Section 1 is the commencement provision. Section 1.2 is a deviation from the standard commencement provision, and it is the result of an opposition amendment that was carried. I did say at the report stage that this amendment to the commencement provision was problematic for us. It doesn't exist anywhere else in the statute book, and it could have been, or it could genuinely have unintended consequences. So my officials are discussing this with the Office of the Parliamentary Counsel, and I just want to highlight that it may require an amendment.
Minister, would you be able to specify the unintended consequences so that we can know them?
You're a little bit previous, Senator, because you will
I
have your
absolutely
opportunity
will,
to make a
but I
contribution
won't
in
do
due
it until
course.
committee stage, but I'll let you know from the amendments.
Minister, you don't have to
beforehand,
respond
no
at this
problem
stage.
Thank
The
you very
Senator
much,
will have an
Minister.
opportunity to make his contribution in due course. Sorry, Minister.
Not at all. Thank you, Chair. Section 2 is the standard provision setting out the definitions. The bill amends the terms of Employment Information Act of 1994 and the Organisation of Working Time Act 1997. I think it's important to remember that the existing definitions in relation to the contract of employment, employee and employer in both acts will apply to this bill. It is necessary to repeal certain sections of existing legislation to improve on them in this bill. Section 3 repeals certain terms of employment listed in Sections 3.1 of the Terms of Employment Information Act of 1994. These terms are inserted into Section 3.1a of the same Act by Section 7 of the bill, so that they are required to be provided within 5 days of commencement of employment. Section 3, subsection B, repeals the existing Section 16 of the National Minimum Wage Act 2000, so that Section 18 of this bill will replace it. Section 4 is an amendment that the Minister for Business, Enterprise and Innovation requested on behalf of the Workplace Relations Commission. At present, the adjudication officers of the WRC do not have powers to compel witnesses to attend a hearing to give evidence in relation to cases taken under the Unfair Dismissals Act of 1997. And the WRC has powers of witness compellability under other employment rights legislation, and the intention is to remedy this situation to put unfair dismissals legislation on the same footing. When the terms of the Employment Information Act was enacted in 1994, the WRC didn't even exist. Section 5 enters the definition of the Workplace Relations Commission into the Act. Section 6 removes the exclusion of employees that normally work less than 8 hours per week, so that such employees will be entitled to receive the written statements of their terms of employment that will be required under the amended 1994 Act. This is to protect employees on low-hour contracts so that they too will be entitled to receive the essential aspects of the employment relationship in writing shortly after starting work for a new employer. The Terms of Employment Information Act of 1994 already provides that employees have to be a month in continuous employment of the employer before the case can be pursued under this Act. That remains the case in this bill, and the provision acts as a deterrent against frivolous or vexatious complaints. Section 7 amends Section 3 of the 1994 Act to require that an employer shall provide employees with a written statement containing the following 5 core terms of employment within 5 days of commencement of employment. Number 1, the full name of the employer and the employee. 2, the address of the employer. 3, the duration of the contract where temporary or fixed term. 4, the rate or method of calculation of the employee's pay. And 5, the number of hours the employer reasonably expects the employee to work on a daily and a weekly basis. And I think this is an important element of the bill, and it's designed to ensure that employees are much better informed of the crucial terms of employment at a much earlier stage. This provision is a significant change which is designed to ensure that employees have much greater clarity and predictability about their daily and weekly hours of work. It is not acceptable for employers to provide contracts of employment that are so vague about an employee's hours of work as to be completely meaningless. Section 8 deals with posted workers. It amends Section 4 of the 1994 Act to require that an employer must provide employees who are required to work outside of the state for a period of longer than 1 month with the written statement containing the aforementioned 5 essential terms of employment prior to their departure. Section 9 sets out matters in relation to existing contracts of employment. The section amends Section 6 of the 1994 Act to provide that where an existing employee requests an employer to provide the written statement containing the 5 core terms of employment, the employer must do so within 2 months. Section 10 is the offensive provision. It introduces an offence for an employer who fails to provide the statement of core terms of employment required under Section 7 of the bill within 1 month of commencement of employment. This section also makes it an offence for an employer who deliberately or recklessly provides false or misleading information to an employee as part of the statement of core terms of employment. For an example, an employer who gives a false name so that an employee cannot litigate against that employer will be deemed to have committed offence under this provision. It's important that this section also provides for appropriate defences for employers, namely so that they exercise due diligence and took reasonable precautions to ensure that the Act was complied with. The ultimate sanction for employers who fail to provide a written statement of core terms of employment or who deliberately misrepresent what is this Day 5 statement is a Class A fine, currently up to €5,000, or imprisonment not exceeding 12 months, or indeed both. However, a Workplace Relations Commission inspector may issue fixed payment notices in lieu of prosecution for less egregious offences. The fixed payment imposed will be less than that of a court fine, and the purpose of creating this offence is to promote better work practices and provide greater clarity around the essential elements of the employment relationship for both the employer and the employee. At the start of the employment relationship, every employee should be entitled to know basic information such as who their employer is, how much they're going to get paid, and what's reasonably expected from them with regard to the normal length of their working day or week. And it really shouldn't be too difficult for employers to provide this kind of information. Section 11 inserts a new Section 6C in the 1994 Act, which prohibits the penalisation of an employee for exercising their rights under the Act. This is a new departure. An anti-penalisation provision has never existed in the 1994 Act. Penalisation is broadly defined in this section, and it includes threats of penalisation and it's important that employees believe that they can exercise their rights under the Act without any repercussions. And I think this is all the more important in case of vulnerable employees. Section 12 provides that an employee must remain in the employment for 1 month before he or she is entitled to seek redress under this Act. It also provides that the employee cannot proceed with a case against an employer that has been prosecuted for the same contravention if it involves the same employee and the same facts. And this is to prevent double jeopardy for employers. There is a similar provision in Section 24 of the National Minimum Wage Act of 2000. Section 13 amends the Organisation of Working Time Act 1997 to provide for the insertion of relevant definitions. And I'd like to take this opportunity to point out that I'll be bringing a government amendment at committee stage to delete the definition of the Employment Regulation Order as it's already defined in the Act. Section 14 amends Section 5 of the Organisation of Working Time Act, which relieves an employer from complying with the new banded hours provision in exceptional circumstances or indeed in an emergency. Section 15 replaces the existing Section 18 in the OWT Act with the new Section 18, and that does two things. It prohibits zero-hour contracts in most circumstances. The UL study found that the use of zero-hour contracts is not extensive in Ireland, thankfully. However, we want to ensure that that remains the position. Such contracts will be prohibited in most circumstances except where they are essential to allow employers to provide cover in emergency situations, to cover short-term routine absence, or if the work is genuinely casual. The section also introduces a new minimum payment of 3 times the hourly rate of the national minimum wage or 3 times the minimum rate set down in an ERO to compensate workers if they are called into work but do not receive the expected hours of work. For example, if an employer calls an employee into work but then decides that they're not needed, the employee would be entitled to 3 times the hourly minimum wage. This is to discourage the unscrupulous practice of calling in more employers that you need and just give the ones that show up first the work. They will hopefully now, under this new piece of legislation, get meaningful compensation for that error. The 3 hours, so it will be the minimum wage multiplied by 3.
You don't have to answer him, Minister. He will have his contribution when his turn comes.
Yes, but this is the way of getting
Yeah, I'm not allowing you. Senator Norris.
To...
Senator Norris, you have this awful habit of ad-libbing when other people are speaking.
Oh, yes,
Please obey the chair. Your turn will come.
Sorry, Senator.
Sorry, Minister, without interruption.
No, not at all. So the current rate, Senator, is $9.55 an hour. Multiplied by 3 would make it $28.65.
And that's the only payment they get?
Yeah, for those 3 hours worked.
Thank you very much.
But the minimum wage
I don't want this going... Senator, you're out of order.
The ERO fixes minimum rates of payment and conditions of employment for workers, usually in the low-wage sectors, and currently the EROs are in place for the contract cleaning and the security industries. There have been requests from some quarters, though, to define casual work. However, the term of work of a casual nature has existed in the Organisation of Working Time Act since 1997 without ever having to be defined. It has not led to a regulatory problem of employers incorrectly categorising employees as casual in the 20 years since the enactment of that bill. And it is not good practice to put definitions in legislation when the plain, ordinary meaning of a word is capable of being understood by the bodies that are adjudicating on it. The WRC and the Labour Courts are capable of examining all the circumstances of a particular case and then making an appropriate judgment as to whether or not the particular arrangement is genuinely casual. They've been doing a sterling job up until now. Section 16 inserts a new Section 18A in the OWT Act, and it introduces a new right for employees who habitually work more hours each week than is provided for in their contract of employment. And it's to request to be placed in a band of weekly working hours that better reflects the reality of the hours that they have worked over the previous 12 months. There was much debate in the Dáil about how workers on low-hour contracts who consistently worked more hours than provided for in their contract have genuine difficulties in applying for mortgages or loans from their credit union or for any interaction that involves a financial arrangement. The situation is also open to abuse by an employer who may use it as a means of exercising undue control over employees, where the threat of being put back on the lower-hour contracts hangs constantly over an employee's head. So, how will it work? An employee will request in writing to be placed in the relevant band of hours. The employer has 4 weeks to consider the request, and the section provides reasonable defences for employers to refuse an employee's request where A, maybe the facts don't support the employee's claim, B, significant adverse changes have impacted on the business, and an example for that might be, so it might lose a very large contract and it mightn't be able to offer the same kind of work. C is in an emergency situation, so we've recently seen some of our business subject to major adverse weather conditions such as flooding, which would impact on their business arrangements. And D, where the hours of work by the employee were due to a genuinely temporary situation. So, for example, somebody might have been covering for somebody on maternity leave and that wouldn't be considered an ongoing arrangement. Where the claim is disputed or refused, the employee can refer to the WRC for mediation or adjudication. If the adjudication officer finds in the employee's favour, the redress will be that they are placed on the appropriate band of hours, and no other compensation is provided to avoid any vexatious or frivolous claims. An appeal against an adjudication officer decision will be to the Labour Court, and enforcement of a WRC or a Labour Court decision will be way of a district court order. The section will not apply to an employer who has entered into a banded hour arrangements through an agreement by collective bargaining with their employees. And this is to recognise that in some sectors, the retail sector particularly, banded hours arrangements have been agreed between the employer and the employees for years and years and have been working exceptionally well. So it is important to remember that an employer is not obliged to offer hours of work in a week where the employees were not expected to work or when the business is not open. For example, a hotel in the west of Ireland's seaside town that maybe closes during the winter months wouldn't be obliged to pay a waiter while the hotel is closed. Chairman, the Government will be bringing an amendment at committee stage to address a drafting issue with the opposition amendment that was carried. It will be to remove the phrase more than and less than. The Office of the Parliamentary Counsel have advised us that this remains, or if this remains, it will cause confusion and uncertainty to both employers and employees attempting to understand the rights provided to them in this bill. The amendment will be to improve the drafting of the provision only. It is not intended to interfere at all with the bans that were agreed in the Dáil. Section 17 replaces the existing Section 26 of the OWT Act to strengthen the protection against penalisation of employees who wish to invoke their rights under this Act. Employees need to feel safe in vindicating an employment right. If an employee believes that he or she has been penalised or threatened with penalisation for invoking any right under the Organisation of Working Time Act, the adjudication officer may award up to 2 years of that person's salary. Section 18 is introduced on foot of the recommendations of the Low Pay Commission in relation to the current sub-minima rates of the national minimum wage. The current system allows for reduced rates of the national minimum wage to apply for those under 18 years of age and for those over 18 in the first and second year of their employment for certain types of traineeships. The LPC's recommendations are straightforward. Firstly, the Commission recommended the abolition of trainee rates, which they felt lacked clear definition around the nature of what constituted appropriate training and were, in any event, relatively little used. And secondly, that the age-based and first employment rates should be retained in light of the statutory protections offered by other employment rights legislation and in order to protect younger workers' access to the labour market, but on a simplified basis to improve both compliance and the ease of operation. This section will mean that nobody who is aged 20 or over can be placed on a sub-minima rate of minimum wage. The current legislation has no upper age limit where there is a person's first-time employment. It also makes provision for the percentages at which these sub-minimum rates are set to be adjusted in the future by statutory instrument, taking into account the labour market conditions at that time. The provision will permit possible further upward adjustment in the rates of a controlled manner where the possibility of any negative impacts on employment for younger people can be monitored and assessed. The Low Pay Commission's recommendations in this matter, grounded on research carried out by the ESRI, were for the first time supported by all 9 members of the Commission, both employer and employee interests, and indeed by the independent members of the Commission. Section 19 will allow an inspector of the WRC to issue a fixed payment notice where the inspector has reasonable grounds for believing that a person has committed an offence. That is not by providing the written statement of core terms of employment within the prescribed time, or by deliberately or recklessly providing false or misleading information as part of the statement. Such fixed payment notices are already issued under the Payment of Wages Act and the National Minimum Wage Act, and this is considered to be an effective way of securing compliance with the relevant provisions and an effective alternative to prosecution. Section 20 deals with the false designation of self-employment. I said at report stage that I genuinely share Deputy OD's interest in tackling bogus self-employment. However, from a policy perspective, I don't believe that this bill is the appropriate vehicle for us reaching a collective agreement on how to tackle it. The amendment is of such potential impact that it should be genuinely subject to proper and thorough scrutiny in a pre-legislative forum to allow both the Houses of the Oireachtas and all stakeholders an opportunity to consider the full implications of what's being proposed. I think genuinely there is broad agreement that the issue of false self-employment deprives employees of important rights, employment rights and the state of employment revenues. However, we already have significant and comprehensive provisions in legislation to tackle it, and we will do more to identify, investigate and enforce the false declarations of employment as self-employment. I'm pleased to note that the Joint Oireachtas Committee on Employment Affairs and Social Protection has commenced hearings on this very issue very recently and has indicated that it intends to examine the issues in a comprehensive manner with a wide range of stakeholders. And I think it's envisaged that this work will take a number of months, and the Joint Committee's work in this area is very timely. I also welcome it, and my department has already attended a number of hearings in the committee, and we are committed to assisting the committee further in its work. And it's against this background it makes sense for this section to be removed from the bill to allow this bill complete its passage through the Oireachtas as quickly as possible. And I'll be bringing a government amendment to this effect at committee stage. To conclude, Cathaoirleach, legislation can be a stubborn creature. It tends to remain on our statute books, and I think we must be cognizant that employment legislation has a significant influence on the labour market. That's why it's really, really important we get this right the first time around. So I hope that we can work together to ensure that this really important legislation, I believe it's probably the most significant employment rights legislation in a generation, can be put on the statute books before Christmas. The bill is intended to help those employees in precarious employments and most in need of stronger employment protections. I believe, Cathaoirleach, they have waited long enough for this legislation. They are relying on us to finalise the bill as quickly as possible, and I would ask sincerely for senators to work with me to make sure that we make that a reality.
Thank you, Minister. I now call on Senator Arda. You have 8 minutes.
Minister, I'd like to welcome you to the House today and thank you for bringing forward this piece of legislation. As you mentioned, this legislation directly affects many people who are on very low, receive very low wages and low-paid workers, as you outlined. Fianna Fáil has supported this bill and will support it through to committee stage. Our party policy is to ban zero and low-hour type contracts that are abusive towards workers. We have consistently advocated our policy for the provision of banded hours contracts that work for both worker and employer in a balanced and proportionate way. These commitments were in our party's manifesto in 2016. Significantly, both of these key features are provided for in this bill and represent progress on policy commitments secured by Fianna Fáil in the confidence and supply arrangement during the formation of this government. Obviously, Cathaoirleach and Minister, we're at second stage at the moment, and we're very happy to work with you through some of the amendments you outlined so that this matter passes seamlessly through committee stage. The main provisions of the bill are to ensure that employees are better informed about the nature of their employment arrangements. It prohibits zero-hour contracts in most circumstances. It strengthens the provisions around minimum payments to low-paid employees who may be called into work for a period but not provided with that work, as you outlined. It introduces banded hours provision so that employees on low-hour contracts who consistently work more hours each week than provided for in their contract of employment are entitled to be placed in a band of hours that better reflects the reality of the hours that they have worked over a reference period. It always strengthens the anti-penalisation provisions for employees who invoke a right under the terms of Employment Information Act and the Organisation of Working Time Act 1997. In relation to zero-hour contracts, amendment of Section 18 of the Act 1997, Section 15 replaces the existing Section 18 in the Organisation of Working Time Act with the new Section 18, which provides as follows. It prohibits zero-hour practices in most circumstances. It provides that zero-hour practices are allowed in limited circumstances, as you explained, emergency, short-term relief, work to cover routine absences. In situations where employees are called into work but sent home without work, There will be new minimum payment of 3 times the national minimum wage or 3 times the minimum hourly rate in an employment regulation order. Employees that are on call will continue to be excluded from this minimum payment. Section 16 in relation to banded hours. The bill introduces banded hour contracts in primary employment legislation. A banded hours system means that the employee is aware of their minimum guaranteed weekly working hours and the likely maximum number of hours that they will be required to work. I suppose how this directly affects employees is that they'll, if they're looking for a loan, if they want to apply for mortgages, they'll be able to, this will be able to be taken into account in their application. So it gives them some certainty in relation to their lives ultimately. Banded hours means that employees are guaranteed working hours that do not fall below the minimum of the band that applies to them. Under the provisions of this bill, an employee will be entitled where their contract of employment does not reflect the number of hours habitually worked per week over a reference period, may be placed on a band of working hours that is a more accurate reflection of the hours worked. And the reference period now is 12 months, was previously 18 months. If an employee believes that his or her contract does not actually reflect the hours worked, an employee requests to be placed on the band of weekly hours worked. The employer will have 4 weeks to consider the request and to place the employee in the relevant band. And disputes, as you outlined, will be referred to the WRC and the Labour Court on Appeal. The section of the bill also includes reasonable defences for employees to refuse an employee's request to be placed in a particular band where the facts do not support the employee's claim. Significant adverse changes have impacted on the business, emergency circumstances, for example, and where the business has had to close due to flooding or other events, and where the hours worked by the employee were due to a genuinely temporary situation. It is important that we balance safeguarding workers' rights as well as employment rights. Minister, you mentioned the Section 20 bogus self-employment. Obviously, Deputy was making a point here to ensure that we tackle the very prolific use of designation of bogus self-employment, not just in the private sector, Minister, but also in the public sector. And it's not just employees who are being deprived of their social welfare benefits, but also the taxpayer, the revenue, are also deprived of employers' PRSI by both the private sector and by the public sector. So it's not just an issue that affects the private sector. Fianna Fáil included and secured this amendment at report stage to make an offence for an employer to incorrectly designate an employee as self-employed. As I said, this was very much to make a point that this issue is a serious issue and has to be tackled, and I welcome that you're creating a separate forum to tackle this issue. As I mentioned previously, we're happy to work with you on the basis that this provision will be removed, so that it goes through committee stage without any issues or without any delay. Our main focus is that to facilitate the passage of this bill, and we under no circumstances want to block this bill. We believe that this is a serious issue that has to be addressed, and we are committed to workers' rights and ending situations where workers are designated as self-employed erroneously. Fianna Fáil's ultimate position in low and zero-hour type contracts have absolutely no security when it comes to hours of pay from week to week. It's very unfair on workers in such precarious positions where they face massive uncertainty week to week and month to month. Under the Confidence Supply Agreement, as I mentioned, we extracted a policy commitment to tackle the problems caused by the increased casualisation of work that prevents workers from being able to save or have any type of job security at all. Workers deserve a fair reward for the work performed. We believe that priority focus should be on low and medium paid workers and improving their job security. Too many workers, most of which are women, are in unstable work as they are only offered part-time temporary employment or 0 hours contracts. We support fair and decent living wages for all workers in Ireland. 0 hours contracts must be changed to allow workers more certainty. Workers in low and 0 hour contracts must be allowed the right to request more hours of work. We support proportionate legislation on banded hours contracts for those on low pay. This will allow workers on low and 0 hour contracts a minimum set of hours and the right to request more hours as practised in other large retailers. As a party, we recognise the majority of employers act in a fair and decent manner and treat their employees appropriately. We will, as I mentioned, be receptive to amendments at committee stage to section 10, which states an employer who fails to furnish an employee with a statement in writing no later than 5 days after the commencement of employment of the particulars of their employment may be subject to a summary conviction to a Class A fine or imprisonment for a term not exceeding 12 months or both. Obviously, this is a civil piece of legislation. In my personal opinion, I don't think there should be any criminal sanctions at all in it. I think the WRC is a very effective tool, and it has, since its establishment, it has been given a lot more powers, and I think it's working very well. Ultimately, we'd be happy to review amendments that you table in relation to Section 10. As a law which states that somebody can go to jail for 12 months, he or she does not provide information, seems disproportionate and unfairly harsh on employers, and we will be receptive to amendments to improve this section at committee stage. I thank you again for coming to the House, and I look forward to the speedy passage of the bill before Christmas.
Thanks, Senator. Senator McDowell, you have 8 minutes.
First of all, I want to welcome the Minister to the House, and secondly, I want to indicate that my own personal support for this bill in substance. I mean, whereas one might instinctively hold back on further regulation of the employment relationship, it seems to me that just looking internationally across the Western world, both in the United States and in the United Kingdom, the Republican value of having a coherent economic community in which there isn't a class of the wealthy exploiting the poor is being diminished constantly. One only has to look to what's happened in the United Kingdom, where, for now 10 years, there's been virtually no change in the real value of workers' wages at a time when the remuneration of those who are wealthy and those who are in charge of the banks and things like that seems to be unlimited. And you wonder what kind of society actually thinks that it is sustainable to have that increasing divergence between those who are at the bottom of the economic heap and trying to participate compared with those who are at the top of the economic heap who are trying to become wealthier. And one only has to look at the divergence in America between the group which they refer to as the middle class, which seems to me to be a phrase which is the working class in our view of the world, and on the one hand, the people working in Walmart, for instance, and the wealthy who seem to be at all costs pursuing the idea that their retirement funds and their personal wealth should accumulate at a far faster rate than the capacity of ordinary workers on whom their wealth is fundamentally dependent. So it does seem to me that the casualisation of employment relations is something which is disempowering for the most vulnerable and unorganised employees, and is convenient for those who are in a position economically to exploit them. And although we are now in a far better position than we were a few years ago in terms of employment, and we're approaching full employment, which should give workers greater opportunities to earn more and earn a more just wage and be more justly remunerated than would be the case if there were huge unemployment. I think that we are right to do something about the disempowering aspects of casualisation, and I do support the principle of this legislation. I just want to say two things about the Minister's speech. I looked carefully at the amendment which was inserted as Part 7 on designation of persons as self-employed. And I know exactly what Deputy O'Dea was driving at in tabling this amendment and I know exactly what he was trying to achieve, which is twofold. First of all, to ensure that those who are in de facto employment actually enjoy de jure rights as an employee, and I'm fully in favour of that. And secondly, that those who are in competition in enterprises with each other are not in a position to effectively avoid their employment law and social welfare law and tax law obligations to the detriment of their competitors, and to drive down, so to speak, their costs by exploiting unfair designation of employees as independent contractors. But I agree with the Minister that and when you look at the long title of this bill, there isn't even a mention of Part 7 and the designation of offence in it, because obviously it was a late amendment to the bill. But I mean, that doesn't. If it should be there, it should be there, and if the fact that it arrives in late is immaterial. But what I would say is that the offence itself of being an offence for an employer to incorrectly designate an employee as self-employed and providing punishments for it, you're creating a criminal offence. And then when you're asked who does commit this offence and who doesn't, you have to go to subsection 8 of that section, and you get two indicative lists which are admitted not to be either exhaustive or in any sense absolutely necessary to determine, for a court presumably, to determine whether somebody is or is not an employee or who is or is not self-employed. And I mean, I just point out to the Minister that there seems to be a drafting error in clause 6, subsection 6 rather. In proceedings for an offence under this section should be a defence for the accused to prove that he or she exercised due diligence and took reasonable precautions, or any person under the control of the accused to ensure that this designation is correct. There's even a drafting error there, and I don't blame a deputy for making an error of this kind, but it's not. It would have to be reconsidered. And then you go to on page 19 of the bill to characteristics, indicative characteristics of self-employment, and one of them is that one of them, the characteristics of employment is that the person receives expense payments to cover subsistence and/or travel expenses. I can well imagine self-employed people asking for subsistence or travel expenses in carrying out a function. I mean, and I don't think that would actually tip the balance one way or the other. But when you come to subparagraphs E, F, and G, it seems to me that they are not, in my view, indicative of self-employment or non-self-employment, or, for instance, at paragraph J, the idea that you have a fixed place of business where materials, equipment, etc. can be stored. I don't think that necessarily is an indication that somebody is, or the absence or presence of such a fixed place of business is an indication of whether somebody is or is not a self-employed person. So that, and I should also say that I agree with the Minister that the table at page 15 to the table in section 16 should be amended in the way the draftsman is suggesting, because it is confusing in the form it is. But I do welcome the bill. I happen to agree with the Minister on both of those issues, and I would just ask all members of the House to listen carefully to what the Minister has said, because she is making reasonable points and she's not attempting to avoid the problem of false designation of self-employment, but she's asking the very reasonable question: is this the vehicle to do it, and is penalisation in a summary offence going to be effective, and is the formulation of criteria for deciding whether somebody has or has not been falsely designated, as set out in the particular section, an apt one to underlie a criminal conviction beyond reasonable doubt against an individual who may or may not be trying to do his or her best. Thank you.
Thanks, Senator. Senator Butler, you have 8 minutes.
Minister, I'd like to welcome you into the House, and I think it's the first time I've been talking to you in the House since the budget, and I'd personally like to thank you for what you've done for the self-employed in the budget. You recognised the self-employed, 400,000 of them. For the first time through social protection will be recognised in the middle of next year with a job seekers payment. So thank you very much, Minister. This bill provides that employers must give employees 5 core terms of employment within 5 days of commencement of employment. Employers who have not provided this statement after 1 month will be open to prosecution. This is a new offence. It will also be an offence for an employer to deliberately misrepresent the information required in the statement of the 5 core terms. The bill provides prohibits 0-hour contracts in most circumstances, except in situations of genuine casual employment and where they are essential to allow employers to provide cover in emergency situations or to cover short-term absence. All employees, including people on if and when contracts, will benefit from the balance of measures provided in the government bill. The bill provides for a new minimum payment for low-paid workers who may be called into work but sent home again without the promised work or any meaningful compensation. The focus here is on low-paid employees. The bill provides for a new minimum compensation payment of 3 times the national minimum wage hourly rate, or 3 times the hourly rate set out in the Employment Regulation Order, the ERO. Traditionally, EROs have operated in low-wage sectors. Currently, EROs are in place for contract cleaning and security industries, providing for minimum hourly rates of pay of €10.40, €10.80 from the 1st of December 2018 and €11.35 respectively. The provision is to low pay to ensure that the measure is focused on those most in need of stronger protections in this area. It is expected that this provision will also act as a deterrent against the unscrupulous practice of employers calling into work 10 people, for example, where there is only work for 5 people, and the first 5 to show up get the work. This bill introduces a right for employees whose contract of employment does not reflect the reliability of hours they habitually work. This creates difficulties for employers in assessing credit, including mortgages. Under the bill, such employees will be entitled to be placed on a band of hours that better reflects the hours they have worked over a 12-month reference period. The banded hours provisions will significantly improve the predictability and security of working hours for employees so that they can better plan and get on with their lives outside of work. The bill provides strong anti-provisions for employees who invoke their rights under this legislation. This is a key element of the bill, particularly for workers in less secure employment who may be afraid to exercise their rights. Now, Minister, we've had a lot of talk about bogus self-employed, and I am delighted that its Section 20 has been removed from the bill, and we're going to basically put it through the Joint Oireachtas Committee of Social Protection and commence hearings on the matters, because I first-hand have seen during the recession where a lot of bogus self-employed people, through no fault of their own, they were given big fancy, in the courier business, they were given big fancy vehicles to, when things were going well, to drive round, and the terms of employment was that you were made self-employed. and these people got on, and when things were going well, they made a living for themselves. But when the crash came, and basically they were bogus self-employed, and they were absolutely entitled to nothing. And it was horrendous what families had to go through to try and get social protection payment, and in certain cases it took 12 to 18 months before a payment come through. So I welcome that we're going to look at this through the Social Protection Committee and to bring in stronger legislation in this area, and I congratulate you on this bill and look forward to bringing it further in this House.
Thanks, Senator. Senator Gavin, you have 8 minutes.
Yes, indeed, let's go here. Look, Minister, you're very welcome. I want to welcome you, and I want to welcome this important bill. I know this bill has been a long time in the making. I know there's been consistent and persistent work done by my colleagues from the Irish Congress of Trade Unions, from my own union SIPTU, particularly from Mandate, and indeed the Unite Union as well. And I want to acknowledge the work of former Minister and our colleague Senator Nash as well, and that very important report from the University of Limerick on zero and low hour contracts. I'm also delighted to see that a number of aspects of my own party's banded hours bill have been incorporated into the Act, and I think this is in due recognition of the work of my party colleagues David Cullinan, John Brady and Conor McCabe. I thought it might be useful just to start by talking about these contracts that are enforced on people, maybe giving a couple of examples. Here's one from the hotel industry, very commonplace throughout Limerick. Given the nature of the hotel business, the hotel cannot be specific on the number of hours each member of staff will be required to work each week. Here's one from one of our manufacturing sites, a very prominent one in Limerick. Hours of work are solely dependent on the department and daily volume of orders that need to be completed. This can and does vary on a day-to-day basis. The company operates from Sunday to Saturday. Goes on to say the company reserves the right to change these working hours should circumstances require it. As much notice as possible on any such occasion will be given to you. On occasions, however, little, if any, notice will be possible, and you should be aware of this. That's a standard contract in a very prominent manufacturing site in Limerick. Here's another one from the nursing home industry. Your normal working hours will be up to 48 hours per week, Monday to Sunday. It's as stark as that. People often ask me, I suppose because my background as a trade union official, well, you know, okay, these contracts exist, but how common are they? They're extremely common, and they're becoming more common. One of the frightening statistics I saw just today, is that of the jobs created in the last 15 months, 66% are temporary in nature. Now, that's quite shocking to think about. Notwithstanding the very good rates of employment growth, but to think that 2 out of 3 of those jobs currently are temporary in nature. That comes from CSO figures, comes from Michael Taft, a very well-respected economist. So we have a major problem. There was a fantastic piece of work launched last week. Indeed, Senator Nash was at the launch alongside me. Precarious Work, Precarious Lives by the Task Organisation by Sinead Pembroke, which details that, for example, in Ireland at the minute, 20% of workers are part-time, many of which is involuntary part-time. A further 8% are on temporary contracts. A further 2.5% are agency temps. So we're looking at a big portion of the workforce who have inflicted these type of contracts. And it means, as you've rightly pointed out yourself in your speech, and I welcome your speech, Minister, that people have no security. They can't plan for the future. They can't get a bank loan. They couldn't even dream about a mortgage. So it's important that this bill is enacted. And while we would have some concerns around the bill, I want to assure you of Sinn Féin's support for the bill, and we will do all in our power to ensure that the bill is swiftly completed. That includes trying to complete it this evening. So I might shorten my speech in order to allow others in, because I think I'm right in saying we're due to finish at 7. Is that right?
Adjourn at 7.
Well, I would encourage colleagues to perhaps take a lead from this. I don't think we need to come back and do this a second day. So I'm going to make my final points pretty quickly, if you don't mind. And I mean that respectfully. I know everyone has important points to make, but we need to get this bill through before Christmas, as the Minister says. And you'll have our support, Minister. The few other points I want to make is I welcome all of the provisions in the bill. I think the point about specifying hours is very welcome. I'd like to see a complete ban of if and when contracts, but we're going to support this bill as it stands. The point about introducing a floor payment is very welcome and very important. And as I say, we particularly welcome the type of bans that are in the bill at the minute, the narrow bans. We're happy to look at the point you make in terms of how to redraft the more or less, and hopefully we won't have any issues in relation to it. A couple of last points I'll make, if I may. I do think we need a definition of casual work. The reason I do, Minister, and again we're not going to object to in this bill, is because I see it so prevalent in Limerick across the hotel sector. People working for years in hotels under a casual contract of employment. So there is a problem there. I want to talk about the self-employment issue. Deputy OD's amendment is well intended, but it will delay this bill, and therefore we're going to work with the government to ensure this bill comes through. There is a major problem with self-employment, bogus self-employment. I speak from my experience as a union official. It's a big issue out there, and I think we do need new legislation. The legislation as it works isn't comprehensive enough. I'm hoping, as you say, that the Committee on Social Protection will deal with that and deal with it swiftly. We do differ with you in relation to sub-minimum rates of pay, Minister. You know that from a previous conversation we've had. But again, we're not going to lodge objections at this point. We want to see this bill come through. The last point I would make is it's really important that we look at the WRC resources. We know that €444,000 of unpaid wages were recovered last year in the food and drink sector alone from 600 investigations. But the fact is, when you have a compliance rate as high as 54%, sorry, a non-compliance rate for employers, that tells you we have a major problem. So we do need to look at that issue as well in terms of making sure we have higher resources. I would respectfully disagree with our colleague, Senator Ardar, in terms of criminalisation. I think we do need it. And the reason we do is because, unfortunately, increasing numbers of employers are ignoring WRC recommendations and even enforcement orders. And I've brought some of those issues to the attention of other colleagues of yours in the Cabinet. Look, I'm going to stop at that. I think it's a bill we should all welcome. I think it reflects well on you, Minister. I think it reflects well on the committee. I think it reflects well on the tremendous work of the trade union movement and colleagues across all parties. I wish it every success.
Thanks, Senator. And next we have Senator Kelleher. You're sharing time with Senator Higgins. Is that agreed? Yeah. Agreed.
Again, we'll be brief. I'd like to welcome...
Is it 4 and 4?
4 and 4 or less.
Yeah, okay.
Speed up. I'd like to welcome Minister Doherty to the House and to commend the Government for this really important piece of legislation. As a former member of Mandate, I'd also like to commend their work, particularly in pushing for this piece of legislation, and obviously there's other trade unions have been involved as well. It's a long overdue step in the way that it promotes workers' rights, a realisation of the plight that many workers in our workplaces, in services, retail, in the hospitality sector face every day, in the care sector, in the cleaning sector, in the security sector. Very often women actually forced into these kinds of works, and with the subsequent knock-on to the effects on their children and the poverty that ensues. So this bill, I agree with John Douglas, General Secretary of Mandate, which represents some 40,000 workers. He says that this bill is the single most important piece of legislation for vulnerable workers in decades. And you know, it is an urgency for us to get it through and to work speedily to get it over the line. Providing for a prohibition for 0 hours contracts, contracts that are deeply damaging for employees, again, many of them women, bound by them and the effects that it has on their families. These contracts create a dictatorial environment where there is little or no certainty for the employee in hours or conditions. These blatantly unfair practices push people and families into the grip of poverty, and I welcome moves to abolish them. I welcome the minimum payments and the disincentive that will create for employers for calling people in when they don't need them and then not giving them work. The banded hours provisions are to be welcomed, and I particularly welcome in section 7, 9 and 10 the written statement of core terms and conditions, because very often people don't know what they're entitled to, what they can ask for. they really don't know. And it is shocking that people don't. So that in itself, and that piece of writing that people are entitled to, that written statement, I think will go a long way in enhancing workers' rights, and also for people to seek redress when these are infringed. I'd like to commend the spirit of the bill and the protection, as I said, of the most vulnerable workers. I am concerned about bogus self-employment. I am concerned about those people delivering food to us, and it concerns me when those very often young people, if they have an accident off their bicycles, well, you know, who will give them, who will look after them? Where will they get the care that they need? So maybe it doesn't fit within this, but it is an urgency. And I do really feel that we are exploiting our young people, particularly in exposing them to that kind of employment. It is grossly unfair. It is dangerous, and it does need to be outlawed. And as I said, if it can't be done in this piece of legislation, it has to be done elsewhere. But we have a chance to outlaw some deeply unfair practices with this piece of legislation, to make those practices illegal and outside the law for now and for good, and to do all that we can and must do to protect those vulnerable people as well, who may not come within the remit of this. So I commend this and share the time with my colleague.
Okay, thanks, Senator Higgins.
Thank you very much. Again, I will try to be brief, even though there is so much that is very positive in the bill, and there's many sections which I'd like to really specifically commend, but there may be that opportunity at committee stage as we go through some of those sections. I think there's a lot of thought in many of the sections. For example, I'm very happy to see the narrow bands within the banded contracts. I think there's a number of good decisions that have been made in that regard, and I think it's important to maintain that. I had the opportunity of launching Task's report last April on living with uncertainty, which looked at the social implications of precarious work. And it looked at both the context in terms of the pressure, abuse and exploitation, the very significant impacts on health, on family life, on security, on the capacity to engage or to plan for the future, as has been outlined by others. And of course, then there is a knock-on effect in terms of our communities, in terms of the social fabric and social cohesion of our communities. Because one of the things that is impacted is not only people's own family life, but their capacity to engage with others and to kind of build society. And I think I won't go into length on that. That report then was followed up with the more recent report on precarious work, precarious lives. I think the impacts are very, very significant and are of a serious concern, not just to the individuals affected, but to all of us in society. Because I'm trying to be brief, I'm going to speak just to 2 or 3 concerns that I have, though I would again acknowledge I'm extremely supportive of this bill, and I welcome the bill, and I will seek to expedite its passage through the House. I am concerned that there are areas which may prove to be loopholes, not necessarily designed to be so, but may in the future. The University of Limerick's excellent research was mentioned, and I know at the time, for example, and even there was something I learned newly when I was examining this bill, you know, we had been told always that 15 hours was what people got if they didn't get, but you know, when you look to the actual 1997 arrangement of Organisation of Working Time Act, you see that it can be less than that in many cases. And there had been a perception that that was the default form of contract, when in fact, if and when contracts were what were prevailing. And the University of Limerick really, I think, gave huge insight into the ways that loopholes were being used in a way that wasn't being monitored. So an amendment I might look to, and I'd be very happy to work with you, Minister, on it, is I do want us to build into this bill some form of review or capacity so we can examine a few of the areas which may become loopholes in the future and ensure that we're not waiting a decade for university research to identify them. The areas where I'm seeing are the concerns around if and when, the questions, those questions of how hours are determined. Is it usually 15 hours? Is it a default? You know, in terms of, are we having a situation in terms of what hours are given? The other questions are, for example, the caveat which allows an employer for an exemption if the employee would not be available for any other reason. How is that going to be defined? The question of casual work and the question of protection against penalisation. So those are just, I may come back to you, Minister, but there's a few areas where I feel we could schedule a review to ensure that the bill is functioning as planned. Self-employment has been addressed. I certainly wouldn't like to see it delayed because of the committee, but we will continue to press in it in terms of the committee. And the issue of appeals on scope determination of self-employment is something we can progress even in the absence of legislation. There is concern about the overturning of scope determinations of self-employment, of not being employee status. I'll come back to you on that. Last one, Minister, I'd urge you to consider considering amendments. I know this was debated. Is the request for more hours? The request for more hours is a crucial issue, that employees should have that right to request further hours. I think it's something we see in the committee in terms of the issue of people who are having to access family income supplement, or who indeed find themselves 1 or 2 hours short of accessing family income supplement. Again, maybe, Minister, that's one we could address at committee stage. Thank you.
Senator. Senator Nash, you have 8 minutes.
Chair, I can't guarantee the Minister that I'll be brief, and I hope she will indulge me for a few moments, or indeed that you might indulge me. Cathaoirleach, I'm very pleased to have the opportunity to contribute to this very important debate. I want to welcome the Minister and her officials, who have worked very, very hard over a long number of years to get to this point. I also, in fairness, Minister, want to give you your due credit for sticking with this particular project. I wondered at times whether or not we'd ever get here. But we did, and it looks like there is some light at the end of the tunnel after all. As you referenced earlier on, and thank you for your kind words, 4 years ago I was involved in appointing Dr Michelle O'Sullivan and her team in the University of Limerick to undertake a study on the prevalence and impact of zero-hour and low-hour contracts in Ireland, and we asked that team to develop with us some recommendations as to how this whole policy area might be best addressed. And this initiative, I guess, was part of a broader and interconnected set of policy interventions that the last government undertook, designed to make work pay and to make sure that people were guaranteed a greater dignity, a greater degree of dignity at work. And they included the establishment of the Low Pay Commission, increases to the minimum wage. You correctly point out the fact that we have the second highest minimum wage in the European Union at present, the re-establishment of employment regulation orders, new sector employment orders, and the institution of a new constitutionally robust system within which collective bargaining could take place in this country. And these changes really did positively impact on probably about 250,000, maybe up to 300,000 workers, and they're workers who continue to benefit from that. So when we introduce good legal minimum standards and enforce them, our economy and our society does well. And this flow of rights and flow of decency benefits all of us. And at the tentative, very early stages of our economic recovery, and I think we all remember only too well, the focus of everyone was on getting people back to work. That was the ultimate objective for everyone. And remember, of course, at the height of the economic catastrophe that we hit in this country, that we had 500,000 people who were out of work, 500,000 people who were jobless. Back in 2011 or 2012, there were so many people in this country who left work on a Friday or closed the doors in their business on a Friday evening, not knowing whether they'd have a business to go back to on Monday morning or whether they'd have a job to go back to. But for me, that targeted focus that the previous government had on job creation was never just about a job at any price. It was about the creation of sustainable jobs where conditions were decent and where the pay rates would allow one not just to exist but to live. And all around us we could see, and Senator McDowell mentioned earlier on, the growth of casual and atypical work. And it wasn't a phenomenon that just grew up out of the recession. We could see for many years that the traditional employment model was fraying around the edges. And we all knew, of course, as well, that some employers didn't waste the opportunity that was presented to them by a good recession to drive down the pay and terms and conditions of workers. And I've argued to death with economists about the data and the trends on the casualisation of work in this country over the last 20 years or so. And some don't feel that there's a particular problem, and they argue that the data, in fact, and the numbers have remained consistent over the years. Headline-wise, maybe that is the case, and a case could be made to explain that, but the composition has certainly changed, and I would dispute a lot of what economists say, and I would dispute that. A lot of people say, look, casualisation of work is a reality, atypical work is a reality, but I'd never accept either that there should be a cohort of people who would be left behind, and people who wouldn't get the same types of protections and the same kinds of supports that everybody should take for granted in a decent society. We should never be happy that there's a number of people who simply form a subgroup or sub-cohort of our labour market that would be in situations where their work environments would be permanently precarious. People who work hard for a living, Minister, you've said it yourself time and again, are entitled to certainty over their hours and security over their income. And there's no doubt that this bill, which you present here today, which has wound its way through the Dáil over the last few months, reflects the bulk, I think, of the important key recommendations that were made by the University of Limerick team 3 years ago. And I won't go into any great detail around those provisions, only to say that I welcome them all. But for me, probably the most critical reform is the one which allows the reality of somebody's working hours to be reflected in their working arrangements and in their contractual arrangements after a period of time. This will have an enormously positive impact on the situation for workers who find themselves with 10-hour or 15-hour contracts, but where their work pattern finds them working routinely for much, much longer. But as you know, Minister, and I've rehearsed these arguments time and time again, I do have a deep and a genuine concern in relation to one aspect of the bill which I feel is neglected. And the UL study, as emphasised by my colleague Senator Higgins, found this phenomenon that we termed if and when contracts. And since the recommendations from that report were launched in October 2015, I've been a little like a broken record, reminding people of the importance of including amendments to any legislation that might be brought forward to ensure that workers on if and when contracts are protected. I know that you are convinced that this legislation deals comprehensively with that, and I know that your officials are convinced that that is the case too. I do differ with you on that, and that's why I believe we should take what I might term a belt and braces approach and amend the bill to enable all workers, including those on if and when contracts, to have access to the excellent terms and protections that are inherent in this legislation without any exceptions. And I would like, as Senator Higgins would, to work with you and your officials and your team to see if some pragmatic arrangement could be made to reflect my concerns in the bill and to address those issues. I will conclude now by just congratulating you again, Minister, on the work that you've done. And to thank you for sticking with this project. It would have been easy to walk away from it, I should say, and to accept the views of some on the employer's side that there's nothing to see here, that there isn't a problem. But thankfully you stuck with this project. You were true to your own word, true to the programme for government, and credit as well to Senator Eireann. Fianna Fáil did, in their own manifesto, ensure that they wanted this area covered in terms of any future government they may participate in or any future arrangement. So I think there is a consensus in this House and a consensus across society that we shouldn't have cohorts of workers who are simply left behind, that we should have a labour market model that's fair, that respects people's rights at work and ensures that work pays. And I want to work with you over the next few weeks to make sure we finally get this over the line, because the best Christmas present I think that we can provide for workers in precarious work in this country is the protections of this legislation to enable them to have a decent quality of life and to be respected in the workplace.
Thank you, Senator. Senator Norris, you're next.
Thank you very much.
You have 8 minutes, or 7 o'clock, whichever. 8 or 7 o'clock. 8 or 7 o'clock.
Thank you very much. I welcome the Minister and I welcome the bill. I'm 74 years old. I grew up in a different age. Circumstances are changing very rapidly nowadays. When I was younger, when I started working, we had an expectation of a lifetime job and a pension at the end. That's all gone now. We have the casualisation of work. We have disposable workers. I mean, everywhere I look. In my own university, it's the same thing. People get short-term contracts. Same out in RTE. All these big organisations have it. There's been a campaign, I think, Minister would agree, from trade union sources to address this situation. And the campaign, as I understand it, and I've had quite a lot of emails on this subject, composed really 6 target areas. And I think by and large they've been pretty well met by this legislation. To ban zero-hour practices, including exploitive if and when contracts, provide workers with secure hour contracts that reflect the reality of the average weekly hours worked, ensure a maximum look-back period of 12 months or less to calculate the average weekly hours, ensure the maximum width of all band of hours is no greater than 5 hours per week, protect workers from victimisation for enforcing their rights under this legislation. I think all of them have been pretty well addressed. The last one I'm not so sure about, ensuring legislation is implemented so that current workers can avail of its provisions for hours already completed. I don't think that's contemplated by the bill. I think, in fact, it's explicitly prohibited. I said I got a large number of correspondents writing to me. I just put another two of them on the record. One is a very highly educated person, very well informed in this area, and he makes this point. The situation in Ireland currently is not the norm in Europe and is creating a race to the bottom. In Germany, for instance, workers can either work full-time or in a mini job of 15 hours a week with a minimum pay level of €450 a week. These hours can be as flexible as employer and employee like as long as they are met. I would struggle to find anyone to argue that this has negatively impacted the German economy, its employment levels, or its level of female workplace participation. All arguments that critics of this bill have floated. My third and final correspondent is more from the working floor, from the cold face where this legislation really hits. And this is what she says. It's quite a brief statement, but it really is indicative. Please, please pass this bill, as Duns are getting away with so much. If the staff ask for a new contract or extra hours, they are given less hours the next week. Duns will make it harder on workers. For example, when they went out on strike, after the strike, the workers' hours were lowered till the shortfall was made up of what they lost on most days. Clearly, the workers can't stand up for themselves for fear of reprisals. Sorry, I can't give my name. My son works for Duns. That just shows you the degree of victimisation there is. And when you think that the Duns store workers were the ones who went out on strike for apartheid in solidarity with the people in South Africa who were being victimised, I think really we need to listen to that voice from the inside of Duns stores. Now, looking very quickly at the bill, there are a number of, I think, highly important sections. Section 7 is one, where the Act of 1994 is amended by the insertion of a section which provides that an employer within 5 days shall give a certain amount of information. It's pretty basic, Minister, but well done putting it in legislation for, I think, the first time. The full name of the employer and the employee, the address of the employer in the state. I'm telescoping a bit here. In the case of a temporary contract, the expected duration thereof, the rate... Oh, I beg your pardon.
My apologies.
No.
Senator Nash had 8 minutes. You're as the spokesperson, so you're just entitled to 5 minutes. Okay.
Oh, how many have I had?
You have one left.
All right. Okay.
Sorry about that.
So we have a series of things here guaranteed. Then there's offences, Section 10. Again, a very important bit. An employee who fails to provide within the reasonable amount of time, or who gives wrong information, they can be penalised. Then the business about penalisation. I would call it victimisation. And this is being outlawed. Well done. This should be outlawed. The prohibition of 0 hours, absolutely. And this is addressed quite directly. I would say that I am concerned that I think Deputy O'Day in the other House did go to a lot of trouble to provide a very detailed thing about incorrectly designating employees self-employed. It's very detailed. It's very, very important. I know that Fianna Fáil have withdrawn it, but I would urge that this be contemplated with a sense of great...
Sorry, Senator, if you could conclude,
I
I'd
will
appreciate
indeed.
it.
I will in a minute. I've mentioned the possibility of victimisation. There are a couple of other things. The Minister, I think, in her speech, put a human face on the matter, where she talks about no more waiting on a Sunday night for a text as whether we're working 1 hour or 30 hours. There's the problem of people getting mortgages, getting bank loans, all this kind of stuff. This is the human face of it, and this is, I think, being addressed and being properly addressed. I'll just say one final thing. The false designation of self-employment. The Minister says we already have significant and comprehensive provisions in legislation to tackle it. I don't think so. Otherwise, why would it continue? Why would it continue to be a significant feature of employment difficulties? Why is this still going on? And why does the Minister herself say that this will be relegated to a committee to examine and so on and so forth, and that the work is ongoing and that it's so important? I do not believe for 1 second, Minister, that the legislation that we have at the moment is at all adequate, and I call on you to introduce the kind of legislation that's contemplated in the amendment. Personally, I would have voted for it.
Okay.
I'm surprised the Fianna Fáil has withdrawn it, but that's their decision.
Thanks, Senator. I now call on the Leader. You want to make a statement?
That the debate on second stage of the Employment Miscellaneous Provisions Bill 2017 be adjourned not later than 7:10 p.m. if not previously concluded, just to allow for the Minister and Senator Moran O'Connor to reply or to participate in the debate.
Is that agreed? Agreed. Okay. Senator Moran O'Connor, you have 5 minutes.
Thank you, Cathaoirleach and Leader, and I want to thank the Minister again, and I, like my Fianna Fáil colleagues, want to welcome this bill, and I even appreciate, your speech was excellent, and I'll just keep it brief. I'll keep it under the 5 minutes. I suppose I look at it from a different angle, Minister, because we also see how hard that Irish people have worked. We've learned, if we've learned anything from the recession, we've learned that. They work so hard, they've been upskilling, they've been changing their careers, they're moving forward, getting by as best they could. But the great thing about that is that they contribute to the figures that we are constantly quoted about, a return to almost full employment. However, if you ask any one of them, the type of work that they have found is not what we really can call full employment. So these famous figures really are something to be scrutinised. We have seen over the last few years a new category of employee, the 0 hours employee. This employee has a contract, but let me tell you that it is not worth the paper it's written on. It is a contract of employment where the employee is available for work but does not have a specific hour's work. It is a formal arrangement where the worker is required to be available for a certain number of hours per week, or when required, or a combination of both. Employees on 0 hour contracts are protected by the Organisation of Working Time Act 1997, but this does not, Minister, apply to the casual employment. Sometimes they do not feel part of a team. They work just as hard as everyone else in the company. So in some cases they get no holidays, no sick days, no parental leave. Sorry now, Minister, I won't keep it too much longer. I say this because this type of work offers them no security, no commitment, and certainly no standing to allow them to seek a mortgage or assistance with paying rent, because their wages are averaged over the year and they work so haphazardly that their numbers never quite add up. This bill has been sorely needed for a very long time. It has already been too long to get here to us. It is a bill which has some great aspects, and I see the work my colleague, and I think it's only important that we do say the work that Deputy D also has done on this, Minister. I want to welcome anything that would enhance minimum payment to workers called into work only to be sent home. We need to empower the workforce again. We need to see a true reflection of who is working and the types of work that they are doing if we are to make correct policies. We cannot pat ourselves on the back and say the country is working again if so many of our workers never know if they will work next week or next month or for how long. There has been a rise in companies hiring people on this bogus self-employment basis. And Minister, I know that you are addressing that, and I want to welcome that, because these workers do not own their own companies, are not financially in a position to assume risk. They pay their taxes, but they are often seeking assistance from charities because they are caught in these 0 hour contracts. They have little other choice. They want to work, so let's put the power back into their hands and get them the real contracts. And again, Minister, look, and I know you've said this and other speakers have said, we do know that we have very good employers out there, and I think it's important to recognise them, and I think, but this bill is needed. This bill is needed for the people who need it most. I know myself families that come into my own clinic, Minister, and they can't get mortgages because of these 0 hour contracts. So I really believe that we need to get this through before Christmas, and well done, and I think it's really good, and this is really positive for the working person. Thank you, and thank you for allowing me to speak.
Thank you, Senator Moran O'Connor. And now, Minister, to conclude, thank you very much. Go ahead.
Thanks, Chair.
For your own information, this needs to be concluded by 7:10.
Oh, I'll be much faster than that.
Excellent.
I just want to thank everybody for, first of all, their praise for the bill. And can I just say genuinely, when we do pass this, and we will pass it before Christmas, this will be a collective achievement, because this isn't, I say this a lot, and I don't think I can overemphasise it. There's no monopoly on wisdom in any political party or none. Everybody in this House, and indeed in Dáil Éireann, has an opportunity to enhance somebody's idea, and this idea I suppose was sprouted a long number of years ago, but as various deputies have said, it's in lots of party manifestos, it's in lots of speeches that advocates give or that unionist representatives give and have done for a long number of years, so that when it is passed, it will be much better than it probably was when it was first mooted, and it will be our collective achievement on every side of the House, of both houses of this Parliament. So I want to thank you for the praise that's in the bill. I also want to acknowledge, as Jed did, the work of the officials behind me for the last 4 years to get it to where it is, and to thank them for their hard work. There's two small little things that I just want to say before I wrap up. I know myself and Jed differ on, I think the if and when is managed well within this, you differ, but I'm certainly willing to talk to you and yourself and Alice Mary over the next number of days, and if we can come to some accommodation, then we certainly will. If we can't, I hope we won't fall out about it. The second thing is that I think it's a good idea to have a review. I know most legislation is supposed to be reviewed after 12 months, but we're all busy and we move on and the next issue comes around. So if there are any unintended pluses or minuses, I think we should have a look at it. So maybe we could agree when that should be, and I can introduce that into a speech at some stage before we go. The last thing I'm going to say is that we've two issues in this country with regard to people declaring themselves as self-employed, whether they do it willingly or whether they don't do it willingly. First of all, we have the loss of revenue to the taxpayer that we all know we could spend in a variety of ways, and it certainly is a loss. I don't know how much that loss is, but even if it's only a small loss, it's still money that's out of the taxpayer's pocket or purse to be able to spend, and it's in businesses' pockets at the moment where it should not be. The second thing I'll say to you is that we need an equalisation across all of our social welfare for self-employed and employed people. It shouldn't matter whether you create your own job or whether you work for Dunnes Stores. The employment rights that you should have in this country should be the same, and the access to social security in this country should be the same. We've started to move to equalise some of the social security schemes. We're now moving to equalise some of the employment rights legislation. So the last, in my view, and I know not everybody agrees with me and not everybody on my own side of the House agrees with me, right? But the last thing in my view to equalise this particular situation is to remove the reason why people declare themselves as self-employed. And I think if we can equalise that particular last platform, then there are no advantages anymore to being self-employed or employed, other than if you truly are self-employed, you have the ability to direct your own work, which is what self-employment should actually be all about. It's the creation of work for both yourself and for other people, and also the ability to direct that work. So the monetary difference, if it was taken out of the equation, I think we would see that issue being very, very, I suppose, with a bit of a sledgehammer being addressed. But anyway, that's, I think, for the future work, and we are going to address it in the JOC and to find other ways of maybe have a looking at it, and I look forward to making my own contribution. But just to wrap up, Chair, I think this is a significant piece of legislation. People have said it's once in a generation, people have said it's a number of decades. I know Senator Manana said that there are people watching us tonight waiting in expectation to be able to ask their employers to put them on a particular band of hours, which will be reflected on the work that they've done in the last 12 months. I think that will be a collective achievement, and I think it will be a job really, really well done by both houses of this office if we can do that before Christmas.
Thank you, Minister. Now I need to put the question that the bill be now read a second time. Is that agreed?
Agreed.
Agreed. When it's supposed to take committee stage? Next Tuesday?
Next Tuesday.
Thank you. And is that agreed?
Agreed.
Agreed. That concludes item 2. Thank you very much, Minister Regina Doherty. And we wait now and we'll move on to item number 3.